लाइव जाने में भी अराउंड 10-20 सेकंड्स लगाएंगे ना, अभी
हाँ,
टेक
पर अभी
सपोर्ट है।
3-1 पे करते हैं।
ठीक है सर, कोई दिक्कत नहीं, 3 हो गया, मैं और 30 सेकंड्स की बात करूँ।
Recording in progress.
हाँ, 1 मिनट। गौरव सर, अमिता मैम, इफ यू कैन प्लीज ऑन योर वीडियो। आशीष सर, कैन वी गो लाइव नाउ? स्टार्ट करें?
या ओके।
वी यस यस वी कैन।
Okay. Good afternoon, everyone. I, CS Ashish Karodia, Council Member of ICSI, extend a very warm welcome to all our esteemed participants and to our distinguished speakers, CS Amita Desai ma'am and CS Gaurav Pingle, for this second webinar under the Master Knowledge Series EEE6 on the topic the Corporate Laws Amendment Bill 2026. Friends, as you are aware, Shrimati Nirmala Sitharaman, Honorable Union Minister of Corporate Affairs and Finance, introduced the Corporate Laws Amendment Bill 2026 in Lok Sabha on March 23, 2026 to amend the Companies Act 2003 and the Limited Liability Partnership Act 2008. The bill has now been referred to the Joint Parliamentary Committee for further consideration. Friends, this landmark bill is a progressive step towards enhancing the ease of doing business with a strong focus on decriminalization, explanation, and reduction of penalties for procedural lapses. As the corporate and regulatory landscape continue to evolve rapidly, driven by technology advancement, globalization, and increasing governance expectation, it becomes essential for professionals like us to stay updated and future ready. Friends, the proposed amendments are expected to significantly impact corporate governance practices, compliance frameworks, business facilitation, stakeholder accountability. In this context, today's session has been thoughtfully organized to provide our members with a comprehensive understanding of the key amendments, their practical implication, and the opportunities and challenges they present for professional and corporates alike. Today, to deliberate on a proposed amendment in the Corporate Laws Amendment Bill, we have with us two speakers, CS Amita Desai ma'am and CS Gaurav Pingle. I would like to introduce the speakers one by one. CS Amita Desai ma'am, she is Company Secretary and Insolvency Professional and co-founder in Corp Advisory Services Private Limited. Madam brings nearly 3 decades of expertise in corporate governance compliances. She leads the corporate secretarial services practice at Incorp, advising a wide range of clients from startups to multinational uh, corporations. Her extensive experience covers IPOs, merger and acquisitions, corporate restructuring, and internal expansion, with successful assistance for formation of subsidiaries in the UK, USA, Germany, and Singapore. Beyond her advisory work, she is a respected speaker and author on corporate law, committed to fostering transparency and ethical practices in India businesses. Her career highlights include contribution to high-profile IPOs, appearing before the National Company Law Tribunal, and receiving recognition from the ICSI for her distinguished innovative careers of 25 plus years. So it is our privilege to warmly welcome CS Amita Desai ma'am. Our second speaker for the session is CS Gaurav Pingle. Gaurav Pingle is practicing company secretary and is consulting and advising companies, compliance officers, CFOs, director on corporate law matters, which includes company law, foreign exchange laws, and SEBI listing regulations. He holds a master in commerce, a degree in law. He is a fellow member of ICSI. He is frequently consulted on critical corporate law matters and interpretations issues in corporate laws, and he provides legal opinion on the same. He has authored several books on company law and securities law, and is often quoted in several business newspapers on regulatory development in corporate laws. Presently, he is the consulting editor of Corporate Law Advisory Journal. We warmly welcome CS Gaurav Pingle. With such a distinguished panel, we are confident that today's session will be highly insightful and enriching. Now, I welcome everyone to this vibrant webinar, and I encourage all participants to raise their queries, which will be taken up either during the webinar or at the end. Once again, I warmly welcome you all and wish you a highly informative and engaging session. With this, I now invite CS Amita Desai ma'am to share her insight on the topic. She will cover the proposed amendment in the LLP Act 2008, the Companies Act 2013, as well as key areas such as ease of doing business, private placement, share capital, debenture, general meeting, NFRA, CSR, and compromise arrangement and amalgamation. So once again, welcome you, ma'am. Over to you, ma'am.
Thank you. Thank you, Ashish ji. Thanks for the nice introduction and setting the tone for the entire webinar. And thanks again for ICSI to arranging such a nice, innovative and a timely webinars to learn from for all the students and the professionals. Thanks again giving me this opportunity. I'll just share my PPT and we'll start the session. I hope it is visible.
Yes, ma'am. Perfectly visible.
Yeah. So today's webinar is on the Corporate Law Amendment Bill, Corporate Laws Amendment Bill 2026, which has been recently placed before introduced in the Lok Sabha, and Lok Sabha has given this to the Joint Parliamentary Committee for examination and suggestion. Once the suggestion will come, then it can be with the approval of President and assent, and then it will be notified. Ministry may take its own time to notify. Maybe by section, the effective date will be implemented. But basically, this bill is aimed to ease of doing business, making more decriminalization of all the offenses which are procedural matter, and certain ambiguities are there already, and that will be brought to the more clarity. And continuously, we are seeing the the landscape or the economic affairs are also getting changed, and some more private placement and security laws are also, they are aligning with the new concept of how to compensate the employees. We'll see this bill is basically recommendation given by the Company Law Committee in 2022, and many of those recommendations are accepted in a different form or mostly in a similar format. Though there are certain more recommendations, we are expecting that it should also be in the book, in the law book soon. Those recommendations are still pending. But this corporate law amendment bill is changing the Companies Act and the LLP Act. LLP Act 2008 has been modified or amended only once, and Companies Act, we have seen there are more than 4 or 5 times the amendment has come, and that will be all welcome. And the law is structured like that it will be evolved with the economy, change in the economy also. We'll see present amendment first in the LLP Act. LLP Act, there are not multiple changes, but it is basically connecting to the IFSC, because we are seeing the GIFT City is also taking some more stability and growing. Now it is in the growing path. We have seen that first listed company also got listed in GIFT City. So the definition part has been changed, wherein IFSC authority, permitted foreign currency, and specified IFSC LLP are defined under the law, under the LLP Act. And this specified IFSC LLP will be specified by the central government once the law and the rules will be out. It will be mandated for this specified IFSC LLP to have a registered office inside GIFT City or inside such IFSC authority or the area. And the name of this company, or the name of the LLP should have a suffix of IFSC LLP, so any layman understand this is the IFSC LLP and not the ordinary LLP under the on the offshore, I mean on land. So incorporation also, the amendment has given liberalization, like self-declaration is permitted. The company can, the designated partners can give a self-declaration that the compliance has been complied with respect to incorporation. Unless they engage a professional, then only the professional need to give such kind of a declaration. That is also not in the format of affidavit, has been, already been amended earlier. Now it is again no need of professional also to hire, to save the time and to save the cost also for LLP incorporation. The partners and the changes in the partner was used to be only with the intimation with the SEBI and IFSC, but now those are also required to be intimated to the ROC. Prescribed class of companies will be again prescribed by the central government. Form of contribution in IFSC, a welcome move where there is a permitted foreign currency is also allowed. All those are also need to declare only in the, not in the INR, but it is mandated now to give a disclosure of the contribution of the each partner in a permitted foreign currency. This is a welcome move for IFSC LLPs. Moving to the register value requirement, section 247, when we come under the Companies Act, we'll see section 247 has been amended, and this entire 247 section will be applicable now to the LLP also, wherever there is a valuation requirement is there. Permitted foreign currency, the definition is changed. The contribution can be taken by the partners in the foreign currency. Similarly, specified IFSC LLP also are permitted to have a maintain the books and financial statement and the reporting also with the registrar of company or the IFSC authority to be given in a permitted foreign currency. Under the LLP Act, power is given now to the ROC also that they can ask for the requisite information from such LLP, and if they do not fail to give that, then the penalty is levied at 10,000, a fixed penalty. A welcome move has come like a conversion of trust into LLP. A fifth schedule in the LLP Act is also notified, which will give all the process and requirement and the flow of how it will happen, a conversion of a trust into LLP. This could be advantageous because many alternate investment fund AIF are registered as a trust. Now they have option to change into the trust into LLP also. We discussed already that specified IFSC can intimate the filing electronically through into a foreign currency, permitted foreign currency also. More structured appeal requirement has come into both under the Companies Act and under the LLP Act. The proposal is that appellate jurisdiction is now set up under the central government only. If anybody is aggrieved against ROC or RD's approval or any orders, they can go for this appellate authority. Adjudication penalties are even in the same way in the Companies Act also. The statute so far in the current act, both in the LLP and Companies Act, there is no suo motu application has been provided under the section. And now this LLP Act also, subsection 76A, allow that a partner or the NLP or a designated partner can make a suo motu application for any adjudication of the penalty. Central government has derived the power that they can withdraw or withdraw the complaint already, which is in the fine, and now into the penalty, and they can transfer such matter from the court to the adjudicating authority, which is regulator. So these are all basically proposed changes in the LLP Act. We'll see about the Companies Act. What are the main purpose or the bill covers? I will just try to put the section wise what are the aim or the purpose. Major purpose, if we see, ease of doing business, as Asisji also set the tone that this bill proposed maximum relaxation, decriminalization, bringing clarity though, and removing the ambiguity, empowering central government to set up certain authorities like NFRA, valuation, and then recovery mechanism also. I think Gaurav will take over that under the adjudication process. Those are all empowering the central government to set up this kind of authority or a fund, and more powers are given. In this bill, we are seeing that there are two funds are set up. One is NFRA fund and one is a Consolidated India fund. And we also see that there are two standards which are mentioned, that a cost standard and the valuation standard under both section of relating to the cost auditor and the valuation. Those standards they can be recommended by those authorities, and central government can roll out later the standards also. We also see in the bill there are more trust is imposed on the business owners and the corporate by giving a self-declaration at a time of incorporation of the companies or in the incorporation of LLP. We see a self-declaration is sufficient. Similarly, for buyback, the declaration of solvency also can be self-declaration. No need for any affidavit form or notarization. Similarly, for ultra small companies or where there are public interest is less or the borrowing may be less, no audit requirement for the balance sheet. The balance sheet will be self-certified by the business owners. That's more trust is reposed on the corporate. If we see the proposal for ease of doing business, the first and foremost, the small company's definition is widened now. The criteria for the small company to fit into the small company are two. One is a paid up capital, which was earlier 10 crore. Now that threshold has been increased to 20 crore. So, and similarly, turnover 100 crore is increased to 200 crore. So any company with a paid up share capital of 20 crore or below that and turnover less than 200 crore are classified or qualified as to a small company, and automatically many exemption privilege will follow. The lower limit will remain the same on the paid up capital 50 lakh and turnover 2 crore. We'll see that many more companies will be covered, but certain companies will still be outside the small company definition because of the relation of holding company and subsidiary company. They are formed as a Section 8 company or they are a body corporate governed under the Special Act. Those are not classified in spite of having a below the threshold limit of paid up capital and turnover. We see what are the exemptions and privilege which are available to small company. Exemptions are for dematerialization of security, which otherwise is mandated for every company other than the small company, and certain more exemptions are there, but small company are completely, they need not provide the demat of security. There will be only one board meeting in a calendar year is permitted. Exemption from certain forms to be filed with ROC is not required to be certified by the professional. They can also avail as a small company fast track merger and take the speedy mechanism of under the regional director, and being a small company. There is no rotation of the auditors also required. We see the average board report and the annual report also for a small company, not a very detailed like a large company. So that's the benefit. In case of any violation, there are lesser penalties for the smaller company. Half of the whatever has been prescribed in the statute, half of that can be paid by the smaller company. There is no applicability of internal financial control mechanism or a CARO reporting on 2020 to such kind of a small company. They are also exempted from the cash flow statement. We'll see ease of doing business. There are certain more incorporation. We saw already the declaration, self-declaration is permitted. Service of document under Section 20 is now permitted for the e-file electronically by to all the members, because most of the email IDs of members are captured due to the demat requirement or otherwise. So due to digital era and protection of the environment, there is no need to print the entire annual report or notice. Whatever you want to, company wants to send to the members can be sent by email. We also saw that IFSC share capital under those jurisdictions, those companies which are incorporated in IFSC under the LLP also, we saw that they can convert their share capital also into the permitted foreign currency. They can maintain the books and records and file the documents also with ROC in a INR, in a foreign currency, except the fines and penalty which could be in the INR. Otherwise, they can use foreign permitted foreign currency. Private placement we'll see again in detail in the next slide. Buyback, I think with that also we will see in the next slide what are the further relaxation has been given. With respect to the charge, there was a major issue that if the company delay after 60 days, there was no mechanism where the registrar can register. So now government has prescribed that certain class of company which it will prescribe, where the registrar will, the application can approve and charge can be registered with the levying of the ad valorem fees also. We'll again see about the AGM, EGM and the notice also, and the ease of doing business, the new provision which has been inserted. Exemption of CSR also we'll see in detail. Relaxation for the audit also we'll see. Resignation by KMP who are not directors can also be directly filed with the ROC. Of course, they have to take care of their labor laws and also their contract or the notice period, and they can file first with the company. In case company fails to file their DR 12 or any intimation to the registrar, then they have authority, they can file on their own also. This was the relaxation for the company secretaries. Many times the company do not file the then the company secretary were not able to join any other company because the dean was associated with the earlier company. We will see with respect to the scheme of arrangement separately and next few slide. Appeal to restoration of the company. Now the power under section 252 is given to the regional director to declog the NCLT, because once the ROC strike off the name of the company under 248, the restoration application used to go to the NCLT, which is very much procedural part. So it is better, it is an ease of doing, and declog the NCLT and they can focus more on the litigation, on the law part. This regulator is RD, regional director, is now being empowered to restore the company. More relaxation has come under the penalties under section 403. Already it's 100 rupees per day penalty, but still the ROC and the central government thought that company ROC should have, or the central government should have, all the financials and annual return of all those companies which were earlier vanishing companies or which were not filing due to various reasons. Now central government can still prescribe certain class of companies can still file with the fees lesser than 100 rupees, and maybe such kind of a CFS scheme can be rolled out by the government to update the data which they have in the system. Lesser penalties for certain class of more companies like small company, OPC, startup, producer. They may be liable for half the penalty, but now the maximum limit has also been prescribed. Maximum it can go up to 2 lakh per company and 1 lakh to the officer in default, which is also a welcome move for such a small class of companies. They should be exempted with the lesser penalty, because in the initial foundation years, they may skip some compliances. So that's a welcome move. Settlement of contravention, first time it has come into the system or into the law book. Of course, Gaurav, I think he will be taking care of this settlement. There is a new system which has been now rolled out. Appellate authority, we discussed in the LLP also. Similarly, above regional director, any appeal can go up to the appellate authority. Faster exit scheme also. Now summary liquidation, where the company is very small, ultra small company with just 1 crore of assets, can be liquidated by appointment of the insolvency professional under section 361, read with section 271. First time foreign companies are also, which are having the branch or office in India, their contravention now is decriminalized from fine to penalty. So it's a welcome move. These are all the section where decriminalization of offense, the move is from the any violation will be from fine to penalty has been moved. With respect to the private placement and share capital and debenture, section 42 and 62 and 42, the first, there was a ambiguity about the section 42 where it was mentioned issue of shares under private placement, where the title has been changed now, issue of securities. So any securities under the Security Contract Regulation Act 1956 will also cover now. Section 42 will be applicable. One more welcome move has come, like equity link compensation instrument are also now part of the ESOP kind of a scheme, which will be like anything, a more specific word has been used, linked to the value of the share capital of the company. Wherever any compensation or any kind of a scheme is rolled out to retain and compensate your employee, which is not particularly employee stock option, but another kind of instrument where there may be a restricted stock units, SAR, which is basically security appreciation right. But if it is linked with the value of the share capital of the company, then also it will be part of your section 42 and 62, wherever the ESOP has been provided. One more maybe little stringent rule has come, like penalty under section 42 for non-compliance of any private placement rules and section. The penalty was earlier up to 2 crore, which is now mentioned as equivalent to the amount raised through the private placement, or 2 crore, whichever is lower. So now it may go minimum as the equivalent to 2 crore. And of course, if the private placement is less than 2 crore rupees, then that amount, and that is a penalty. In spite, apart from that, there will be refund also. But the penalty mentioned, the language up to is changed to the equivalent to. We'll see buyback of the securities, which is like scaling down the company and they want to repay or compensate in a bumper profit to the shareholders. Certain class of companies are prescribed. They can go beyond 25% of the aggregate paid up capital in a 1 financial year. And there could be a 2 buyback also in a year is possible, with the condition that a minimum 2 buyback, the minimum gap between 2 buybacks should be at least 6 months. And same way, like compensation to the employee also can be bought back under the scheme, any scheme which is linked to the value of the share capital. Solvency declaration can be, instead of affidavit, now the company directors can give a self-declaration about the solvency, that after buyback also the company will remain solvent. After buyback, one more this exemption is there, that you cannot issue normally a securities again in next 6 months except the stock option kind of a scheme. So there also the scheme which are linked to the value of the share capital are covered now. Punishment also under the buyback now moved from the decriminalization, now fine to the penalty. And that's for the listed and unlisted companies also it is different. So that's first time in the law it's separated, like for the listed company more penalty, and unlisted or other kind of a company there will be lesser penalty, which is also a welcome move. We'll see about the general meeting, annual general meeting and general meeting. Since COVID, we are seeing that it will be through the virtual meeting, because during COVID, we know that people could not be gathered, and this remain out of statute, and year on year, the ROC is giving the circular with the rules and the method and procedure how to conduct those meetings. Now we see it is in the statute, maybe once this is notified along with the rule that how this can be conducted in the virtual or audio video conference mode, with an exemption that once in a 3 years, every company need to call the meeting in the physical mode, which is also welcome, because many time investors, shareholders want to know and meet the management directors, directly want to ask the question due to technical glitches, or maybe some elderly people not very well versed with the technology, they are unable to attend. So the opportunity is being given that at least company should call the meeting once in 3 years, which is also very welcome move to save the cost, and at the same time balancing act for the shareholders also to meet the person face to face. In case the company has been called by the requisition meeting, the requisition can also ask and demand for the meeting on the virtual or hybrid mode, which will be permitted. Punishment of this default of calling the general meeting, which was particularly mentioned under section 99. Now it covers only 99 section, not a 96 to 99. So it is only pertaining to the AGM. Any default happened for the calling of the AGM, then there is a decriminalization from a fine to move to the penalty, and you can file instead of compounding an adjudication application. EGM, if called by the virtual mode, and all the documents and notices are circulated through the email, then there is no need for traveling by any members. So 7 days notice period is considered as a sufficient, and that's how, if there is any recommendation of JPC, with this will be clear, then it will be easier. In case of emergency situation, companies can call the EGM just within 7 days, because notices will be circulated by EGM. I believe this will be also covered for the postal ballot notice also. Maybe this, we'll see when finally the bill will be rolled out with the rules and everything, with the recommendation also of the JPC. This is an important amendment which has come for the NFRA, National Financial Reporting Authority. We saw in the 2013 Act also, when the NCLT has been set up, there are a number of objections that where the power has been drawn by central government to set up such kind of a court or anything. Similarly, this NFRA authority, there is a question happening that how and what it has been recognized by central government. So first time in the statute, officially it has been recognized that NFRA will be set up as a body corporate and has the independent power to regulate the audit established under section 132. It will have its perpetual succession council like a body, and it has all its power to acquire properties and dispose of the property, sue and to be sued, call for people, summon anybody, and disciplinary action can be taken. So under section 134, again, there is a disciplinary power has been given for NFRA. It can order against any professional or other misconduct. Now, what are those misconduct has been wider now. If we see the definition, the explanation earlier was reading only any violation where it is only under section 22, prescribed under the section 22 of the Chartered Accountant Act 1949. But now with this bill, it has been extended and further elaborated that any misconduct or professional misconduct is relating to contravention of the provision of the Companies Act or any rules and regulation there under where the power or jurisdiction is given to the NFRA, then in that case, NFRA can call any person, issue an advisory, and give the warning also, require any additional professional training to be given to those people, and they can also refer the matter to the central government. Apart from that, they are also empowered to penalize such people and recover also such penalty and by punishing by imprisonment, fine or debarment. So we see that NFRA has given very wide power, not only fine, penalty, recover, but also deterrent, like they can debar any person from the practice or certification work. We see under 132A registration, auditor's certificate. If we see the auditor's registrations and returns are also mandated. Certain class of companies are required that they have to register all this detail with not only the Institute of Chartered Accountant, but also NFRA, and the auditors of those class of company are also mandated to file periodic returns with the NFRA. This may be a larger companies where the public interest is more and they are liable to penalty also if they furnish anything wrong or any misstatement. NFRA fund first time is set up. We are seeing that central government is constituting a dedicated fund where this fund will finance the NFRA entire operations and activities. Direction are also 132C. If you see, NFRA has been empowered to give any kind of a direction, instruction to the auditors. They can summon, enforce the attendance of such people and levy the penalty for non-appearance. And all those penalties will go to the Consolidated Fund of India and not the NFRA. So NFRA Authority Fund will also levy certain penalty and it will go to Consolidated Fund of India. If we see the empowerment of the NFRA, it will override the civil court also. The jurisdiction is beyond civil court. So you cannot appeal to the civil court. NFRA orders can go only against the NCLT. NCLT is the next where it can be made, the appeal can be made. A protection is given to NFRA authorities where they act in good faith. They can be, they are protected. Power of central government, which we are not discussing, that entire power is given to the central government also to give direction, supersede certain time NFRA, or significance of this main amendment is now NFRA is an exclusive body and self-regulated, recognized under the Act, exclusive power with the fund which will use its activities through the fund. This is an alignment of the audit regulator in various Western countries which are already set up there. So before and after NFRA enforcement, we see earlier there was only imposing the fines and debarment, but now further giving advisory first. So first they will give a warning, advisory, give the training, levy the penalty, and last resort they may debar and for any professional misconduct to any auditors. Now the auditor's word may cover not only the statutory auditor, but the cost auditor and the company secretary or the sector auditor, Auditors will face a criminal liability for any non-compliance. There could be imprisonment. 90 days deadline also is given. If the penalties are levied, if not been paid within 90 days, then there will be a imprisonment also. 5 times higher penalties are also on the forms, are also paid, mentioned there. So basically it is, we feel that it will be increasing the quality of audit and investor protection may improve here, but time will say how the jurisdiction of NFRA will be expanded. Coming to the audit and auditors, there are a number of changes. Like small companies, we already discussed that it is not required to have the statutory auditor. It may be a very small ultra companies where public interest may be less. Similarly, like a Western countries, self-certified balance sheet will be accepted. Central government also paving the way for permitting such kind of a multi-dimensional partnership. If we read the fine letter and in the bill, it says that subject to each partner of the firm, they can be registered with a statutory institute or a body established under the law. So that means definitely there has to be multi-dimensionally where the partners can certify. So this, I think it's a welcome move for the multidisciplinary partnership in the future. Non-audit services, now it's a debatable issue. We are seeing that a lot of pushback is coming from the statutory auditor or the chartered accountants. Like a certain class of companies are prescribed maybe by central government where the auditors and audit firms cannot provide the non-audit service, where not only to the company but its holding company subsidiary directly or indirectly, and the cooling off period is a longer period, 3 years, which is not normal case in Western countries. It's not too long. 1 year is okay for a certain class, like for the RBI bank audit, you can have a cooling off period of 1 year, but it will definitely have an impact on the mid-sized company where you are in the audit. Next 3 years, you cannot give any non-audit services also, which will be it will have a huge impact on the mid-sized company. Similarly, larger companies may also be very choosy whether they want to do the audit or they want to do a non-audit service, because otherwise they'll be out of the business for non-audit service for next 3 years, not only for the company, but its holding company and its subsidiaries. And we see that networking, a chartered accountant, large big four will maybe taking it very conservatively and think about it before taking any audit service. I don't want to touch on the penalty part because this is a fine to penalty regime. Cost audit, there is a cost accounting standard may be prescribed later with a recommendation of the ICMAI. Multidisciplinary partnership, here also it has been prescribed by central government. So this is also a welcome move. Accountability is being increased, not only the managing director and whole-time director, but now it will be on the board also. An officer entrusted by the board also will be now responsible for any non-compliances. Punishment also be there. It's been more like a other audit requirement for the statutory auditor. Here also the requirement is more from fine to penalty, but only thing like certain fine under 147(1) is still for the company and officer in default moved from fine to penalty, but on the auditor it is still remaining under 147(2) as a fine, which may be finally when the bill will roll out, we may see some changes here also, that it may be at par and can be brought under the penalty regime. We see the board report, there are one change, only major change, what the more disclosure and transparency and accountability is required. If in case any observation of the auditor with respect to accounts, about the financial transaction, about the functioning of the company, or about the maintenance of the account or any other matter, will be now the board has to reply in its board report that what are the observation and comments and what is the management's take on that. So this will bring more transparency and disclosure. Similarly, composition of the audit committee, wherever it is mandated, that need to be incorporated in the board report. And also one more additional requirement that the board has to give disclosure, which are the recommendation of the audit committee, which has not been approved or board has not accepted that recommendation, and what is the reasoning for that. So with the justification, such kind of disclosure will be required in the board report, which is also a welcome move for more transparency. We move to the corporate social responsibility, a very welcome move. India is the first jurisdiction. We all know that the CSR has been mandated for 2% of the 3 years annual average net profit, and net profit to be calculated as per section 198. These thresholds are 3 thresholds. One is net worth of 500 crore, turnover of 1000 crore, and net profit was set up at 5 crore, which has now been increased to 10 crore, which is also a welcome move. That certain class of companies, that 10 crores requirement is, many companies will be covered now and they may not be required to have a CSR obligation to fulfill. Second recommendation or the relaxation has been given is about the time limit to transfer the fund on the ongoing project, which is a multi-year project, more than up to the 3 years project. There also the time frame was given after the closure of the financial year. Within 30 days, you have to transfer into a separate bank account. Every year there has to be separate bank account. Now the relaxation has come that this bank account can be transferred the fund within 90 days instead of 30 days. So instead of 30th April, you can use by 30th June, this fund should be transferred for the ongoing project. There are no CSR committee also required to be set up where the obligation for the company is just 1 crore. The board itself is sufficient to fulfill the obligation and do all the recommendation and use the money. So there is no need for the CSR committee requirement up to the 1 crore obligation. One more prescribed class, one more central government has given a relaxation that it may feel suitable. It may give some class or prescribe certain class of companies where they are totally exempted from the CSR obligation. So maybe I believe Section 8 company would be one of them. They will be, because their purpose is for setting up for the CSR or the social benefit. They are, or certain more class of companies, depending on what central government will prescribe, we'll see. Compromise arrangement and amalgamation, very interesting. Some amendment has come. One is with respect to, this is very not much important, like liquidator is not now permitted to compromise and apply under the Companies Act for, he should go under the whoever the liquidator appoint under IBC, and during that process he finds that there is a need for compromise with the creditors, he is not permitted here. He will be under the IBC, he will be doing that. Second proviso, which is very important proviso, which has come like for any facilitation of two application of the scheme of merger, and there are two separate jurisdiction of the NCLT benches. The one bench, single bench, will exercise its jurisdiction where there is a transferee company or the resultant transfer company situated. So this will help a lot of hassle and simplification of procedure. Under one jurisdiction of NCLT, your application of scheme will be entertained or exercised all. So that will facilitate ease of working for the merger and acquisition area. Merger and amalgamation, one clarification which is minor, that it's not material, but I just mentioned on my PPT that reduction and extinguishment of share will happen eventually after the merger or amalgamation order has been set up under section 232 3B particularly. This is just to clarify and remove the ambiguity about the cancellation. With respect to measure for the fast track merger under section 233, where the RD has power, important relaxation has come for obtaining the members and creditors approval. From 90%, it has been reduced for the members to 75% of the people or the members who have voted or present and voting in the meeting. Whereas similar thing has not come, unfortunately, for the approval of the creditors, which says 9/10 in the value to the 3/4 in the value, or in writing word is still in the statute. So I don't know how it will be. I hope that JPC or recommendation or the various stakeholders will recommend that this should also be at par with the NCLT under 232, 232, that creditors also in the meeting voting, present and voting should be permitted. So many companies will go under the NCLT, I mean under the RD route and not the NCLT route, which our finance minister also, Sitaramanji, has said that they wanted to expedite a fast track merger. And this is the requirement of the time. So I hope this will be looked into later on. Scheme need not to be filed with the OL when the scheme is for demerger or transferring the division. There's no dissolution happening. So OL requirement has been taken out from the statute. Central government gives certain last and very small, I'll just take one more minute. Treasury shares will be now, it will be given 3 years time to dispose of the shares. Certain recommendations are still not in the bill. We see is all that are prescribed, like fractional shares are not there. Issue of shares at a discount for the distressed companies are not still in the statute. Joint audit, risk management committee compulsory, spec is also not in the statute. And we also see that producer LLP is still pending. We see that register of charge to be maintained on the certain class of companies electronically, and qualification of auditors to be standardized are not in the statute. So I think with this, I may overshoot a minute, but with this, I think my presentation is over, and I'll be happy to take any question answer pertaining to this. We can think after the Gaurav's presentation and take in one go, or I'll leave it for Ashish ji for you. And thank you very much for the patience in listening. Thank you. Sorry, you are on mute, Ashish ji, unable to.
Hello.
Yeah.
Yeah. Many thanks, ma'am, for your for such an insightful presentation. Ma'am, you explained such a large and complex topic extremely well within your time. It was an appreciable efforts, and I don't think it was an easy task. Thank you, ma'am. To
Thank you.
friends, to continue our discussion on the Corporate Law Amendment Bill 2026, we now welcome CS Gaurav Pinglet to the session. Over to you, Gaurav.
Yes. So is the presentation visible? Yes.
Yes.
So thank you ICSI for the invitation, and thank you very much for conducting this particular webinar on the Corporate Law Amendment Bill. There are quite a few important amendments that have been proposed and which have been discussed by Amita ma'am in the previous part. So I will take ahead this session with some few more amendments which are proposed in the particular Companies Act. So just a few disclaimers that the views are personal. As of now, these are proposed amendments, nothing that it is concrete as of now. So it is referred to the JPC. So stakeholders consultation would continue. So these are all proposed amendments or proposed changes in the bill. This background is already provided, so I will go to the next slide. So with respect to the directors, there are quite a few amendments that have been introduced by the or the proposed by the government. In fact, this particular bill, there are quite a few amendments right from incorporation to closure till till the compounding or adjudication, or probably till the last section. The amendments have been proposed. So this is a exhaustive exercise which is done, and there are 107 clauses in the particular bill, out of which 90 relate to the company law and 17 relate to the LLP law. So in 90 also, that 90 is just a number. Internally, there are quite a few further amendments which have been there. For example, if we see buyback, there are 4 amendments with respect to buyback. In the similar case, if we go to section 164, 167 and other provisions, there are quite a few other provisions where there are multiple amendments that have been proposed. So in aggregate, I feel that the total number of amendments would go beyond 200 to 50 in number as of now, before the matter, it comes back to the parliament, and then it would be in a form of a bill or an act. So now this is, as I told you, these are all proposed amendments. So maybe not at every slide I would have mentioned proposed, but all these are proposed amendments with an objective that the participants understand the content and where everything is coming from. I have given references of the particular section as well. So the independent director's requirement, basically the appointment, when we appoint an independent director, the eligibility criteria is not to be considered only at the time of appointment, but it is to be considered during the entire tenure. So that is just being clarified by the proposed amendment. And there were issues where, first an additional director is appointed and then he is appointed as an independent director. So when will the tenure start for the independent director? So it has now been clarified that the date of appointment as an additional director would be considered for counting the period, so that we can calculate the tenure as well with respect to 5 years plus 5 years. So accordingly, there is a clarity. So we need not count it from the shareholders' approval, but we have to count it from the board approval. So there are some provisions where clarification is provided. There are some provisions where the provisions have been overhauled in the proposed bill. Now, just there is one more amendment with respect to the cooling off period, that the independent director shall not be associated with the company. Earlier, it was only associated with that particular company, but now they have extended it to the holding company, subsidiary company, associate company, and they have made the period for 3 years. So practically, we can only consider his appointment after a period of 3 years. So we need to see if at all there is any pecuniary relationship between these companies, not only the appointing company, but also the other group companies at the time of his next appointment. So basically, he should be independent during that time. That is the intention. Now, just some analogy. If we see these provisions as compared to the statutory auditors and that non-audit services in section 144 that has been proposed. So if you see, similar provisions are there even for the independent director, 3 years for the holding subsidiary associate company. So that is also one important, you can say, after reading the bill for quite a few times, I just thought that there is some similarity. Obviously, the constituents are different, auditor and the independent director. Now, there is a change in some thresholds, which is there from 10% to 5%, specifically in relation to the legal consulting firm. But that is one change. So it's quite minute, and maybe just that it is at the bill stage. So maybe we can consider it at a later point of time. But that is an important amendment. So just see, this is section 149, subsection 6, but there are quite a few changes itself in the provisions of independent director. Now, the provisions with respect to DIN, that is the director identification number, this is also quite important, and quite a few provisions have been included based on the experience that we had somewhere in 2017, 2018, when the government had taken an action with respect to the companies which were not compliant in filing the account. So they have ensured that the DIN should be active, the DIN should not be surrendered, and it should not be cancelled, and the director should be compliant. And they are now linking this entire procedure with the provisions of the law and obviously with the MCA system which is there. So now there are quite a few provisions that they have introduced, that the DIN should not be activated, cancelled at any point of time, and verification is done. So we are aware of the KYC. And just on 31st of December 2025, the amendment was there with respect to the KYC. So all this have now been not only rule-based, but now they have specific provisions in the law which is provided. So the DIN can be deactivated or cancelled. So these are now new kind of terminologies or new provisions with respect to the DIN that has been proposed in the particular bill. So that, for example, if he incurs a disqualification, then the DIN would be deactivated. Once it is deactivated, then there would be repercussions with respect to the other provisions as well. So there are now provisions with respect to the DIN which is mentioned. Now there is a specific provision in the law which they are proposing with respect to the surrender of DIN as well. So presently, this is the present provision under section 159, which provides that if a person has a duplicate DIN, or if there is a non-compliance with respect to the DIN, then what would be the penal provision? So there is an existing provision, but if we read it minutely, and there are quite a few adjudicating orders where the penalty is, it goes, there is no cap for the penalty, which is now considered in the proposed bill. Presently, it is 50,000, and if there is a continuing offense, then it is 500 rupees per day. So there is no cap as such. Now there is in the proposed amendment bill, they are making it very specific that it is 50,000 and maximum up to 5 lakh rupees. So this is quite very objective and very clear about what would be the penal provisions in case of non-compliance of the DIN related provisions, which is section 152, 155, and 156. So this is actually a very welcome move, because this was one of the concerns by directors, and the duplicate DIN that they had, where they had obtained when it was not PAN based, and all these present requirements which are there. So very welcome, you can say, proposed amendments which are there. Now, in relation to the appointment of directors, there are few changes, specifically in relation to the additional director, that once we appoint an additional director, the tenure shall be up to the next general meeting or 3 months, whichever is earlier. So it is a bit similar to the provision that we have in the SEBI listing regulations, that if at all the appointment is done in the month of January 2020, or maybe whatever is the year, but we have a general meeting at a later point of time, then we still need to take the shareholders' approval and appoint him as a director. So the present provisions would change about the ensuing annual general meeting, and all that is proposed to be changed. This is purposefully to align with the SEBI laws, at the same time to ensure that there is the shareholders' approval is taken at an appropriate point of time. So therefore, additional director, at the same time, there is a provision with respect to the director by casual vacancy. So wherever there is a director by casual vacancy, even that is to be considered by the shareholders within a period of 3 months from the date of appointment. With respect to the now at the bill stage only, the government has observed that there could be a situation that a person has not been appointed by the shareholders, or approval was not taken at any point of time. So again, that person cannot again be introduced as an additional director or alternate director, or by casual vacancy in some way or the other. Considering that shareholders' approval was not obtained, you can say we have to go back to the shareholders and obtain the approval of the members for his appointment. So basically, the government is through all these proposed amendments is ensuring that shareholders' approval is obtained for the directors, and that is not skipped at all in any case. But now there is a prior shareholders' approval that is proposed, and not the not a ratification in a form. There is a clear provision of a prior approval. Section 164, quite a few interesting developments and amendments that have been proposed with respect to the disqualification. Something new, absolutely new for the company law, and some things which they have aligned it with Section 167 of the Companies Act. This is one provision which is still there in the Companies Act. Basically, this is clause G of 164(1), which says that a person shall not be eligible if he has been convicted for an offense for RPTs. So now what it actually means by the proposed amendment is that if a person, that is, if a director is penalized, means the penalty has been levied under adjudication process, then he gets disqualified to be a director for a period of 5 years. So that is what is proposed. The reason is because Section 188 non-compliance has already been moved to the adjudication regime, and maybe there may not be a conviction unless and until the matter goes to the criminal court for the particular non-compliance. But if the matter is they voluntarily apply to the ROC for adjudication, and the offense is adjudicated and the penalty is paid, then these directors, there is a restriction on their appointment to be the directors in the other companies. So conviction as well as penalty, these are the two changes that has been proposed. Means penalty has already been proposed. But just one important point over here is that there are quite a few occasions, or there are quite a few orders where penalty is levied for the non-compliance of Section 134, that is disclosures, non-disclosures in AOC 2. And that penalty is levied under Section 134 and maybe not under Section 188. So we need to consider the show cause notice and the order that has been passed, and then consider the person for appointment or not. So this is quite, interestingly, this is the only provision where penal provisions or penalty is considered. So for example, if a director is penalized for duplicate bin, he may not be disqualified to be a director. It is only the RPT's non-compliance that would be considered very stringent and will be considered as not eligible for appointment as a director or a disqualification. So let's see how this is there. I think so. This is part of the Company Law Committee report as well. So quite a relevant and an important change which is proposed. Now, with respect to the director disqualification, suppose if a director or a professional has already, he has been an auditor or a secretarial auditor or a cost auditor or a valuer, RV, he's valued certain securities of the company, or an insolvency professional for the last 3 years. Probably they are aligning now the independent director, the auditors and the directors in comparison to the holding company, and 3 years, holding subsidiary associate company for 3 years. Then for that period of 3 years, he will not be eligible to be a director. So after 3 years, he can be a director in the company, but not for the immediately 3 years. So for example, if just an example, if a person has signed a particular balance sheet as an auditor, secretarial or statutory auditor, or issued you can say a valuation certificate or a report with respect to the private placement, and in the next year he is proposed to be appointed as a director. So once these provisions are notified, that would not be possible. So that is one aspect to it. Now there is a proposal that the government is introducing a fit and proper criteria for directors also, and that could be different for different class of companies. So this is for the first time that these provisions are introduced. Fit and proper criteria is there mostly in the case of securities law with respect to the intermediaries. but for the company law, this is for the first time that has been introduced. So let's wait for some rules and clarity on this with respect to the fit and proper criteria. If we see section 164 subsection 2, not the subsection 1, so in subsection 2, presently there is a provision which says that non-filing for continuous 3 years for financial statements or annual return, anyone continuous 3 years, then that would not, the person will not be eligible to be appointed. Now that 3 years is proposed to be made 2 years, basically government is ensuring that timely compliance is made by the directors and the companies in which they are directors. So, and they are also giving a cross reference, which is also the case now, but that is amended in the proposed clause 167. So quite important and interesting, you can say, amendment is suggested. Now, just one point over here, because that was one debatable issue in 2017-2018 when the strike-off took place, that how will you count this 2 years and 3 years from where? So let's wait for the bill and the Amendment Act and notification. So after that only we can comment. But generally, all these laws are prospectively in nature unless and until there is a specific provision that it is retrospective. So let's wait and watch for this particular amendment which is there. Now, in section 165, with respect to the number of directorships, the government is proposing that certain class would be exempted. Either class of companies would be exempted or class of directors would be exempted. So some kind of exemption is expected for the number of directorships of a director. So this is just an enabling provision. Maybe a notification or a rule may be introduced and then the exemptions would be provided. Interestingly, even section 166 is amended. Now in 166, there are quite a few provisions. Around there are 6 subsections which talks about the duties of the director. And then there is one penal provision. Now, one of the subsections, which basically is on the screen, that talks about undue gain and advantage, and basically the person has, or the director has gained advantage or misused the funds or misused the company's assets either through himself or his relatives, and basically siphoned off funds. This is not something that is being decriminalized. For this, obviously the matter will go to the court, and there will be a fine to it. So there is fine and court which is involved over here with respect to this. Rest of the other duties of the directors, they have been decriminalized. Only this law or only this particular provision is not decriminalized. The rest others, they have been decriminalized. So this is a very important amendment for the duties of director, making an exception. There is one more provision where an exception is created under section 186. So we will come to that as well. So this is how they have bifurcated. So except the provisions of what we discussed earlier, there is a penalty for listed company and other companies of 5 lakhs and 2 lakhs, which is proposed. So quite important and relevant for directors, for all the directors, basically independent or executive, non-executive directors, where these penal provisions will be considered. Okay. Now we come to vacation of office under section 167. Though I may not go very much in detail, but yes, they have provided under section 167 that the office of the director shall become vacant under 167 if he is a director and after 6 months, he is incurring any disqualification. So this will be a very important amendment because it includes the company in which the default has taken place, and it also includes the other companies as well. So they have also given an explanation to this. But as even earlier we discussed, let these provisions, again come back in the form of a bill and before the parliament, and then so we can discuss in detail, because maybe there could be some other recommendations as well. But this is what is being proposed in the proposed law. Under section 167 subsection 2, there is a proposal that they decriminalize or they introduce the penalty. So fine would not be there in the case of non-compliance of 167. So basically, there is a provision which says that even if a person is vacated, but he still continues to be a director, then there is a provision for fine. So they have just made it for the penalty which is there. But now, if you see, they say that the DIN has been deactivated or cancelled. So what we discussed in the earlier part under section 150, 152, there is a reference of activated, cancelled, not surrendered, and all these. So they have been linked to section 164, 167, so that requisite powers are there with respect to not being a director in the company. But at the same time, the offense has been decriminalized as well. With respect to section 173, there is an amendment which talks about the company can conduct certain class of companies can have only one board meeting in a year. Year means the calendar year. That is also being clarified. Earlier, there is a provision that gap between 2 meetings and 90 days. Now it is proposed that the OPC, small company and dormant company, they can have just one meeting in a calendar year. So that is what is proposed. So let's see how this takes place with respect to the board meetings. Now, there is a proposed amendment with respect to the director's disclosure of interest. This is specifically under section 184 subsection 1 and not 184 subsection 2. So if we refer to section 184 subsection 1, the disclosure by the director is required to be made in MBP 1 at 3 occasions. So at the first board meeting in which he participates as a director, so maybe at the time of his appointment or after his appointment, he participates. Secondly, presently, he should make it at the disclosure at the start of the financial year. And thirdly, whenever there is change. So now there is a proposal that the second point, that is the annual disclosures, are proposed to be removed entirely. And it is only the first disclosure as a director and the subsequent disclosures, if at all there is any change, would be considered. This is in a way, in terms of documentation or in terms of compliance and disclosures would be less. But now the onus gets shifted on the directors that they have to diligently ensure that the change is reported to the company, because non-disclosure has its own repercussions. But this is quite important that now he needs to take voluntarily action for the change in, if at all there is change in his directorships, wherever he is there. So quite important and quite relevant, but at the same time onerous for the director. This is a big amendment actually, in my view, with respect to the compliance of section 185, loans to directors. In loans to directors, if we refer to the particular provision, there are 4 subsections in section 185. First subsection talks about that there is a complete prohibition on the giving of loan, giving of guarantee or security in connection with the loan. Then subsection 2 talks about that yes, there are certain parties to whom you can give, but that is subject to the company taking the approval of the shareholders, and that the money is used for the principal business activity. That is subsection 2. And then we have got subsection 3, which says that a company can give a loan to a particular company, or you can say loan guarantee or security can be given. However, there is only a condition that the money should be used for the principal business activity. And subsection 4 is a penal provision. That is broadly the scheme of section 185. In that, now in subsection 1, there is a proposal that in clause B, along with firm, there is a reference to the LLP as well. So considering that subsection 1 is completely prohibits the transactions between a company and the parties mentioned over here, that is the director of a company or a holding company, director of a holding company, a partner or a relative of a director, or a firm or a partnership firm in which a director is a partner. So till some, or you can say for the purpose of interpretation, the LLP was considered as a body corporate, rightly so, because of the provisions of the LLP Act. And also that there is a specific provision that the provisions of the firm will Partnership Act will not apply to the LLP. So there is a provision to that. And
Recording stopped.
there is a specific provision that
Recording in
talks about
progress.
the liability of the limited liability partnership. So that has now been included. So let's see how this would be considered in relation to the existing provisions. So there probably would be a prohibition in some kind of transactions. So this was the earlier change was on section 185. Now there is a provision, there is a change in section 186. In section 186, there is a change which actually relates to the penal provisions or the penalty provisions of section 186. I have purposefully mentioned here because it's a very detailed and an exhaustive section with quite a few subsections. So basically, except for subsection 9 and 10, everything remains the same. For subsection 9 and 10, the government is proposing a separate penalty structure. Subsection 9 relates to the maintenance of register, and subsection 10 relates to the inspection of it. So if a company defaults in these two particular non-compliances, that is subsection 9 and subsection 10, then there is a separate penalty structure which is proposed over here. So if a company, this is what is proposed in the bill. So if a company contravenes the provisions of 9 and 10, which we just discussed now, then there is a penal provision. So penalty is provided for subsection 9 and 10. And for the rest of the provisions, the provisions of section 186, subsection 13 will apply. That is broadly the understanding of the proposed amendment. Basically, an exception is created for the two subsections. Considering that these are to be maintained by the company, and there could be a provision for adjudication as well. In section 189, so all these are the sections which are absolutely close to the company's heart and company secretaries working on a regular basis, whether as a company secretary in practice or a company secretary in employment, which is there. So in section 189, there is a provision, penal provision basically, if a company doesn't comply or doesn't ensure compliance of section 189, then presently the provision says that every director who fails to comply will be liable for a penalty of 25,000. But there is no reference for the company being penalized. So therefore, now they are introducing this particular, you can say, a provision in section 189, subsection 5A, clause A, which they are introducing. So basically, company and director both will be liable for the said non-compliance. Yeah, this was very briefly touched upon by Amita ma'am in her presentation. So this provision is somewhat similar to what is there in section 168, which provides that the director can intimate his resignation to the ROC. There is a specific provision which says that the KMPs who are not a director, so a company secretary, a CFO, a CEO, they are the persons who can directly intimate to the ROC about their resignation. So that is what is provided. So there would be a separate mechanism with respect to the forms and filing would be there that can be filed. But this was quite expected and quite sought by quite a few professionals in the recent times. So a welcome move by the ministry to introduce this particular provision. Treasury shares, that has also been broadly discussed, but basically the shares which is which are there with the company, there is a specific provision which says that the company shall deal or dispose of in the manner prescribed. That is the wording which is there in the proposed law or the proposed clause. Now, how do they deal and how do they dispose? And after disposal, what did they do of it? Is we need to wait for the rules, because rules will give some clarity on the way in which the company can utilize the treasury shares typically in the transferee company. And if at all they don't do that, then there is a penal provision then there is a provision which relates to which says that it would amount to cancellation and extinguishment and shall be deemed to be a reduction of share capital. So this is for the first time these provisions have been introduced in the Companies Act in India. So let's wait for some more clarity in the form of rules and in the form of a particular section, and then probably we can see. But there was a specific discussion in the company law committee report. So very relevant that this recommendation is taken up, and this would be quite helpful in companies that go for merger and the shares are held by the transferee company. So there could be some clarity in it. Now, with respect to the valuation, there is a detailed amendment, just like an exhaustive amendment in NFRA, not that exhaustive, but there is an amendment that has been introduced for valuation also. So valuation, RVO, all has been recognized in the section. And the government is also, the valuation authority under the IBBI would be the authority under the Companies Act. That is also what is the bill which proposes for the same. So considering that this is quite important and relevant, so maybe we can see it over a period of time, how this becomes relevant, because related to valuation, there are few references in the Companies Act as well. Yeah, so valuer. So this is very brief about what I've mentioned. Nothing much in detail. I have not quoted the clause over here. Yeah. Now, with respect to the strike-off related provisions, so just for the quick introduction, in subsection 1, the ROC has reasonable cause to believe, and based on the few pointers or few clauses which is there in subsection 1, the ROC can take necessary action for strike-off. In subsection 2, the company can apply for strike-off, but in subsection 2, they have given reference to the clauses which is given in, or they have given reference to the clause or subsection 1. So, so there is a cross reference which is there. Now that cross reference is deleted, and now there is a proposal that if the company extinguishes the liabilities, then company can go for a strike-off. There is no apparent condition which is mentioned over here in the proposed amendment under section 248 subsection 2. But so based on that, it as of now means that if the company has extinguished the liability, they can go for a strike-off. So that is a very welcome move. And just like ease of doing business and ease of setting up business, like we have it for they can be found by the promoters, and there is no specific requirement of engaging a professional. If that is considered as ease of entry, then this would be also an ease of exit for the company. So this is also quite welcome that this anomaly which is there of cross-reference is now being taken away, and quite relevant and helpful provisions are there now. There is a reference with respect to the 2 years of the current year and the 2 years and significant accounting transactions. This is quite relevant because significant accounting transactions are referred to in section 248, but has a meaning to it in section 455, which is the dormant company. So therefore, we need to refer to that. Now, interestingly, the significant accounting transaction, which has around 4 or 5 clauses, it is also proposed to be added, means one more is proposed to be added for the significant accounting transaction. So this is one clause or one proposed amendment which is there. Clause A, there is no amendment, therefore I have not mentioned over here. Yeah, so this is the provision that I was referring to in subsection in the significant accounting transaction. There are 4 existing clauses, and now they say that receipt or payment not relatable to the business or the operations of the company. So this would obviously depend on the facts of the case, but at least if that is there, then there is a provision for strike-off, which is linked to the earlier section. Now in section 2 subsection 248 subsection 2, as I was referring to the proposed amendments, yes, so the reference of the subsection 1 is proposed to be taken away. So extinguish liabilities in such manner as may be prescribed. So maybe the rules would provide for some more clarity, but at least there is no reference to cross-reference to section 248 subsection 1, which is a great, from the perspective of interpretation and applying for strike off and completing the compliance, checking whether you have done business or not. So there are many things that we need to cross-verify before making an application for the strike off, which now there is a clarity. Yeah, now there is a provision with respect to the revival also. This was partly discussed by ma'am in the earlier part, but basically the powers with respect to the revival, there is presently it is obviously with the NCLT. There is a move that this NCLT entire power will go for entire power means the power for 20 years will go to the regional director. If we refer to the company law committee report, there was a proposal that for the first 3 years it will be with the regional director, and for the remaining period it will be with the NCLT. But now in the proposed bill, they have put it entirely to the regional director who can revive the company. So a very important point over here, we are going to refer to section 396 that relates to the registration of offices under the Companies Act. So the regional director definition has been amended in section 2 by this, is proposed to be amended by the bill, and there is a cross reference in section 396 as well. So therefore a very important amendment. Basically, they don't want the NCLT to be, there would be a lot of cases with the NCLT. Typically, these cases with respect to the strike off or revival. So that is proposed that quite a few less. Now, even when we come to the compounding under section 441, there is a provision that the matters are shifted back to the from NCLT to the regional director. Yeah. 366 basically companies that can be, or the entities that can be converted into a company. Earlier it was under Part 9 of Companies Act 1956, but now it is under the section 366 of the Companies Act. So now they are along with partnership firm, LLP, cooperative society, they're also proposing that non-trading company or any other business entity can also be apply for registration under this part. So probably we need to wait for some more clarity on the non-trading company. But there is a provision, or there is a, you can say, a proposal to amend this provision as well. As compared to the company law committee report, this is a very different amendment, but quite interesting one. Now, with respect to the registration of offices, as I was referring to, there is a provision which talks about the officers, that is the regional director, additional regional director. This is what is proposed, that the government may appoint the regional director, additional regional director for discharge of the functions of the Companies Act. So maybe it may happen that in the form of the adjudication or few other powers would be with some other regional director designated as additional regional director or joint or deputy regional director. These are, you can say broadly, these administrative changes, but quite relevant for us, because when we have to go for revival or when we go for a hearing, for example, there is a proposal in section 2, subsection 41, that if a company wants to change the financial year of the company, then obviously we need to make an application to the RD if it is a subsidiary of holding company. So we have to prove before the authority. Now, there is a proposal now that if a company wants to change the financial year, now considering that it is no more a holding company or a subsidiary company of the holding company in the foreign jurisdiction, then you can change the financial year, but you need to make an application to the authority. So there are several occasions where we need to make an application to the authorities, and we need to understand that who will have the powers in terms of. Therefore, these amendments are quite not only administrative, but quite important for us as professionals to understand. Now, just to give you an example, very recently, the MC has issued a notification, and in quite a few other states, including Maharashtra, the office of ROCE, the jurisdictions have changed. So even with respect to the RD and all, so we need to consider this So not that it is a very academic amendment, it's a very important amendment. And considering the fact that quite a few provisions or quite a few powers which are there with the NCLT are now coming to the RD, we need to be conversant with these provisions. Yeah, the same cases with respect to the registrars. So because the registrars would be the first in line with respect to adjudication related proceedings. So government may appoint registrar, additional joint deputy and assistant registrar or such other officers with respect to discharging the functions under the Companies Act. So this is also a new amendment or a proposed amendment, which I've purposefully mentioned in the slide so that you all can refer to the same. This is one very important amendment, mostly for small companies, private companies where there is a default, and the per day 100 rupees was one concern in the recent times. But the government has addressed it in the proposed bill, and so quite important and quite relevant for all the professionals, whether in practice or employment, relating to an amendment to Section 403. I have purposefully mentioned this in the slide so that we understand where the exact amendment would be there. So we have a subsection 1 which talks about filing of certain forms, and then there is a reference of additional fee. So presently for non-compliance of 92, Section 92 and Section 137, there is a provision for per day 100 rupees. Now there is a proposal that lesser amount of than 100 would be proposed. So definitely lesser than 100 would be there for maybe a class of companies or for all the companies. So that would be there by amending the rules or by issuing a notification in this regard. So therefore, this is what is there. At the same time, the other provisions are not proposed to be amended, but there is also, as in the earlier slide by ma'am, there is a reference that the penalty will be restricted to an amount of 2 lakhs and 1 lakhs, which is there, which is part of our presentation. So that was also a point, but that is under Section 466, which will come to. But this is a welcome amendment that has been introduced by the MCA with respect to the penalty for the annual compliances. Yeah, for 441, there is presently the threshold that says that up to 25 lakhs, the matter will be handled by the regional director of fine, 25 lakh rupees of fine. Now the threshold is proposed to be increased to 1 crores. So typically compounding applications which are there now compared to what the government has done an exercise of decriminalizing the law in the year 2020 and as well as in the proposed bill, quite a few offenses will come under adjudication. But at the same time, there will be quite a few offenses where compounding would be relevant. These offenses would be taken care up to 1 crores, where there is a fine of 1 crore, up to 1 crores will be with the regional director. So basically the thresholds have increased and matter will be with the regional director and not with the NCLT. So beyond 1 lakhs, the matter will go to the NCLT. 1 crores will go to the NCLT. That is what is the amendment. So Section 441 is proposed to be amended only with respect to the monetary threshold. Yeah. So there is also one very important and relevant for the professionals who are practicing in NCLT, that the president may consider constituting one or more special bench of NCLT to exercise the powers for disposing under Companies Act or IBC. So this was a suggestion by quite a few professionals as well as with respect to this having exclusive jurisdiction for certain matters. So that may see the light of the day in the coming future. So they have made an enabling provision in the Companies Act. Yeah, this is which relates to the provisions of Section 446. This is quite relevant, and this is one of the very important defenses which the companies and the professionals provide when the matter goes for adjudication. typically in the case of one-person company, small company, startup company, or producer company, only these companies can take advantage of this particular provision. That what it says is that basically the government is removing the uncertainty that the penalty shall not be more than one half. So when it says shall not be more than one half, then it can be less than one half. Then it can be, so that can be zero also, or it can be maybe some amount lesser than what is the penalty. Now there is a clear-cut provision which says that it shall be liable for a penalty of one half. That's it. So suppose if there is a 4 lakh rupees which is mentioned in the section and it is a small company, then the penal provisions will be 2 lakhs, straightforward. So there will not be a case where we can argue for a lesser penalty, lesser than the lesser penalty, which is proposed in the amendment bill. So this is also quite relevant and important in having a clarity so that the directors or the company is absolutely clear on how much would be the penalty. So there would be some clarity on this particular aspect. So that subjectivity is removed by this particular. And also they have mentioned a particular percentage which says that or such percentage not exceeding 1% of the penalty. So there is some clarity or certainty on the amount of the penalty. That is what is the amendment with respect to section 446. With respect to the fraud, also there is an amendment. As I said, this particular amendment bill is touching upon all the important aspects. So we are on section 447, and there is still an amendment to dormant company. There is an amendment to section 469. So quite a few amendments are there till the last provision, from the first provision till the last provision that we have the proposed amendments. So yes, so far with respect to this particular clause of section 447, the monetary threshold is proposed to be increased in it. So presently it is 25 lakhs. They are proposing to increase the same. So yeah, in with respect to the adjudication of penalties, yes, this is also one very important point. Presently, if we see, there are quite a few applications which are made by the company through e-form GNL1, which are voluntary applications. And based on that, the show cause notice is issued, and then the adjudication proceedings are initiated under the Companies Act. But if we see the Act and the rules, there is no clear cut or there is no specific provision which says about making a suo motu application for the same. So there is an enabling provision which is being proposed in the amendment bill that the company or the officer in default can make an application. So just supporting the present practice with respect to the adjudication. And additional ROC is also now appointed for adjudication proceedings along with the registrar of company. Assistant ROC. Assistant ROC is also authorized along with the registrar of companies. So the government will notify the appellate authority in addition to the regional director. So presently we have the order that is passed by the ROC and then appeal to the regional director. So the government will prescribe a provision, maybe by way of a rules that would be there with respect to the appeal in case of adjudication. These provisions are like both the provisions are somewhat relating to the securities law, and the first part, which relates to the recovery of amount, is probably referring to the provisions of the securities law as well as the income tax law, where the penalty is levied but the amount is to be recovered. So that is what is the present provision. So there is a separate provision now that the government is introducing with respect to recovery of amounts. So the government is proposing that if once the penalty is levied and it has probably been appealed or not appealed, and so the penalty is levied but the penalty is not paid. So what authority or what right does the government or the MCA or the recovery officer have in this regard? So in relation to that, these powers are now being introduced. So powers, they are there with respect to attachment of property, or quite a few wide powers have been provided. And if at all required, they can take the assistance of the local district administration. That is also one of the, you can say, the provisions that have been provided. By and large, this scheme of the recovery of amounts is a bit similar to what is there in the SEBI Act or the income tax law. Maybe not that much in detail for income tax law, but there are quite a few subsections in this regard, because maybe the government would have observed that the order is passed, but the penalty is not paid by the defaulters. So therefore, this provision has been introduced. In fact, one more interesting provision is there with respect to the settlement. So if there is a contravention only relating to penalty, so in all the you can say the offenses where adjudication is done, or adjudication is the only outcome, or adjudication is the only penal provision, only those provisions can be considered for settlement, not any other provision like fine or fine and imprisonment they're out of question with respect to the settlement. So in this case, the government can constitute authority, a group of officers to discharge the functions with respect to this particular function. So let's see how this is there, because there would be a detailed rules for this, and this will take some time because this is a very means a huge process in terms of the administration and the function. So let's see how it takes place for with respect to the settlement under the Companies Act. This is also, in my view, the first time that settlement related provisions have been introduced in the Companies Act along with the recovery related provisions which is there. Now, yeah, so in case of appeal, if the matter goes to the appeal, then there is a specific provision which says that the matter should, means the persons who are making an appeal should deposit at least 10% of the amount when they are going for an appeal. So that is again a bit similar to what we have it in the case of the income tax and the GST in the case of appeal. So this is in the case of order passed by NFRA, valuation authority, and the adjudicating officer. So this is a common section for all the three provisions. Yeah, dormant company, which I was referring to. So basically, in the dormant company, it provides that where a company is formed and registered for a future project, but has no significant accounting transaction. Presently, it's optional for such companies to make an application for dormancy, but now it has been made mandatory, or it is proposed to be made mandatory, that these companies shall make an application to the registrar. So basically, government is making it very strict in terms of either you do the business, or if you're not doing the business, then you may go for dormancy, or maybe there is a strike-off provision that you can you can say you can make an application for strike-off. So government is in a way providing all possible options with respect to this particular amendment bill. So let's see, but basically they are making it mandatory. So maybe all these amendments, once they are effective and all, we need to take stock of our clients and check the balance sheets, check whether there are significant accounting transactions, whether these are actually significant accounting transaction as per the definition. And based on that, then we can take a call with or discuss with them with respect to making an application for dormant as a dormant company. Then we have to read even the rules, which is the miscellaneous rules in MSC form that we can apply. So this is quite interesting amendment, because presently there is an option given to the company, but later on the company, it is made mandatory that it is on their own that they have to identify and make an application. Yeah, presently there is a provision which talks about now a proposed provision which says that government can issue directions and guidelines or circulars. Basically, it provides that there could be a consultation with the expert bodies, and based on that, they can clarify the rules or provide a clarity. And then there is one more clause which I have not mentioned here, but in case of some emergency, they can issue the amendment which is there. So quite a relevant provision that has been introduced. This is not the last provision which is there part of the bill. But yes, so this is the last slide with respect to the corporate law amendment bill. So we can have some questions in this regard.
Okay.
I
Thank
think
you,
just
Gaurav.
I will just to make 2 points here. I think dormancy company is a very scary. Many companies which are not just holding the project or a land or IPR, they are also now forced to go for the dormancy immediately. Otherwise, there is a deterrent that they will be striked off. So that is also very important. And the second one is the scary one is a recovery officers are set up and they have a wide power. They can attach your movable, immobile assets. They can be debar. I mean, they can detain and imprisonment. So these are all very stringent for provision. I think dormancy they require central government because to clear their where they can overlook because certain companies they are just coming in the way which are not doing any operational part, so they are rather pushed to go to the dormancy so they can monitor more effectively those companies which are active company. That could be the one of the reason, but depending on the presentation recommendation what it comes we'll see. Important one is a loan to LLP is also now in the no, under 185 completely. There are two things. One you can do with the approval of the special resolution, and one you can't really do at all. Like you cannot give loan to the director or firm in which director. Now the firm covers LLP, which is very good move, but the entire corporate has to now restructure the way where they LLP also cannot be a wholly owned subsidiary. So there will be a way to find a solution to this, but very welcoming move. I hope and some corrections will be definitely there and the recommendation before the final rules and act will be notified. Thanks. Wonderful presentation, Gaurav. Thank you. Thank you, Ashish. Yeah. Do we have question answer?
Yeah, ma'am. Thank you, Gaurav, for sharing your valuable insights and detailed analysis on the corporate law amendment bill, and your presentation has been highly informative and engaging. Now we will move to the question answer session. We have received some great questions, but out of questions received, some are suggestion about what should be included in the bill, which they can email to ICSI at Companies Act 2013 @ICSI.edu. And many questions have been received regarding the impact of the new provisions and the changes likely to result from these amendments. So we will take one by one. And now, first question for Amita ma'am for you. And the amendment in LLP incorporation mean LLP can be incorporated by partners themselves and no professional certification is required.
Yeah, that's what the proposal says, a self-declaration by the proposed designated partners and partners is sufficient. No professionals are required.
Yeah, thank you, ma'am. Gaurav, for you, related to AGM, listed company also needs to do physical meeting once in every 3 years.
Yes, so as of now, as per Companies Act, yes, means as per the bill, yes, but maybe let's see how the proposed bill and the SEBI regulations are harmonized. But as of now, at least based on this, answer would be yes.
Yeah. For you, where the board members itself constitute the CSR committee, it is sensible to exempt such companies from having CSR committee, so as to avoid unnecessary CSR meetings.
Is it for me?
Yes, ma'am.
Yeah,
For you.
yeah. CSR, if the obligation is just 1 crore, no, there is no need to burden with the CSR committee. So the board itself can also handle, and such might be the small companies where the 2% maybe of average is coming to 1 crore, not a large corporate. So the board will be properly equipped to discharge the function of CSR committee. Not required, according to me. That's what the
Okay,
bill
thank you.
says. Yeah.
Another for you, ma'am. The small companies are not required to appoint the auditor and audit the accounts.
Yeah.
So what is, yeah.
That's also welcoming because in Western countries the corporates are respected and trusted. So self-declaration with a deterrent that there are penalties, people will behave. That's the trial they will start, and I think central government will specify very small companies, maybe where there are not much bank charges are there, or there's no much bank loan, and the interest of the public is lesser. To start with, I think there will be such kind of a class of companies will be prescribed. It will be tried and tested, because so far we are always under the regime of somebody is checking and somebody is reporting. Now self-regulation, I think that's the way forward to move in the economy. So I think central government is proposing this, which will be a good move for small companies.
Yes, you are right, ma'am. At this stage, many details will only become clear after the bill is passed, because the prescribed limit for each provision will be notified then. So,
Yeah.
wait and watch.
Sir, just just one point.
Places, the classes
with
of
Yeah, go ahead.
companies
respect to
are sorry.
Yeah, so
I
with
was just
respect to this
saying,
amendment bill, so there is a enabling provision which is provided in the law, means through the bill. So later on, obviously the government can assess and come out with a notification and say that these class of companies may not require audit or not. So it's still a very long way to go till that stage, I feel.
I think the entire bill, the number of places it is mentioned that the prescribed class of companies. So there will be a specific rule. I think that's the beauty of this act. I find that the rules will go on prescribing depending on the evolution of the economy. So such kind of companies will be prescribed time and again. They don't have to go to the amend the law. So power is given to the central government. Yeah.
Okay, next question for Gaurav. Gaurav, if any person has been appointed director for even one day, we are not able to surrender his dean. Is there any change in can we surrender dean of any person who was previously appointed as a director and now for 3-4 years he is not a director in any company?
Yeah, so I also encountered this particular provision or a situation. So presently there is no provision as such for surrender, because if we see the rules under the surrender of DIN, there is no as such provision, because the exact situation which he says that if he is appointed as a director, then he cannot surrender the DIN. It's a complete exception to that. So presently there is no provision as such, but in the recent times, the DIN application for surrender have been taken up by the MCA, considering that there have been quite a few cases where duplicate DIN is generated. So based on the declaration and affidavits, probably, but maybe that can be tried, but not that is which is explicitly provided in the rules.
I think so far
Okay.
the
Yes, ma'am.
it was not part of the statute. Now it is coming at the part of the section, and then the rules will follow and the forms will be there to surrender the deed.
Okay, ma'am. Ma'am, for you, in the fast-track merger, there is a provision to take 90% approval from the shareholders, which is not practically possible for a listed company, although it is merging its wholly owned subsidiary company. So by default, we have to go through NCLT, which takes more time and cost.
Correct. That is the reason I think the provision now change under the 233 fast track route with RD, that members who are present and voting of 75% of those people, I think sufficient. But the similar provision has not come for the creditors. So for the mid-size or large company where there are a number of creditors, then 3/4 in the value is required by not by voting in person and present, but in writing also. So RD's hands are tied for the creditors. But I think for members, 3/4 present in the meeting is sufficient. 75% voting, which is at par with the NCLT route. Under section 230 also, it says the same thing. Members present in the meeting. And where there is a court convened meeting. Here in the EGM itself or the general meeting called by the company, you can have a approval. So it's a ease of doing. The entire provision is proposed for that purpose.
Gaurav, for you, under the amendment 164 1G, the director will not be eligible for appointment to same company or any company. Appointment to same company or any company. And is there a time limit proposed for this disqualification?
Yeah. So there is a provision which says that, or in the bill I'm saying, there is a proposed provision which says that for a period of 6 months or the tenure of that particular director, till that point of time, he can continue, but after that, not. So that is the provision.
Okay. Ma'am, auditor report contains various notes and observations. Should board report provide explanation for each note?
Here the comment, earlier we used to do currently any remarks, any qualification, whereas going forward, it suggests that any comments or observation also should be replied by the audit, by the management, not just the qualification. Qualified and adverse remarks we are doing, but currently, but not every comment. That's what the disclosures are not proper or transparency is not coming. So this proposal has come. And which is a welcome, all the comments which means there is a contrary to the law, any comments are made need to be replied by the management. Yes.
Okay, thank you,
Yeah,
ma'am.
so basically,
Gaurav, yeah.
yeah, so basically we cannot club all the qualifications and give one comment. We have to give clause by clause comment. Probably that is what is the intention, madam.
Okay, perfectly fine. Gaurav, section 248 subsection 2 is applicable to section 8 company?
No, if we see the rules, then as of now, there is no provision for Section 8 company to make an application for strike off. So therefore, this provision is not applicable to Section 8.
Okay. Ma'am, for you, what is the take on proposed amendment in section 88?
What is that section 8? I need to see. Section
Notice
80.
of the trust.
Notice of the trust. Yeah, section 88 is a register of member where we are specifically currently also and in under 1956 Act also. We were never taking the note in the trust name was never coming into the register of member, which is this as a clarificatory or a clarity for the any ambiguity or questions are coming. So it has been specified that no trust will be registered in the register of member. Maybe for DMAT also. That's another provision. DMAT trust are certain time permitted, but I think in the register of member we cannot put the name of the trust. The trust cannot be a member.
Yeah.
That's what I think it's been clarified. This is just a clarificatory.
Yeah. So basically, there was a provision in Companies Act 1956. Now that is now just being reintroduced in 2030. Now.
Yeah, it also say the same thing that trust name cannot be registered in the register of member. I think 187 or something, 187C.
Okay. Gaurav, can a company provide loan to any other unrelated LLP in which no such director exists?
Yes, of course. Sorry.
Yeah.
Yes, so
Yes.
there is no as such any restriction in the law, so they can provide.
185 restrict only where the company or firm or where the director or his relative is a director. If it is totally unconnected, it can be given. But again, you have to see the section for the kind of giving the loan or the receiving company has to check that. Company can give the loan.
Yeah, even under
Or
section
question.
189, 179 also they can give the loan. So that provision is there. Yes.
Okay. Ma'am, for you, related to CSR, where a company has in a previous financial year, a CSR obligation exceeding rupees 1 crore. But in subsequent financial year, its CSR obligation falls below 1 crore. Whether such company is required to continue maintaining a CSR committee?
Yeah, I think that also let's wait for the rule to rolled out because currently the limit is 50 lakh. Now it has been increased to 1 crore and the other provision remain the same. Till you exhaust that 50 lakh, your committee continues. So similar rule will be extended. Only the limit has been extended from 50 lakh to 1 crore. Rest of the provision remains the same, which means you have to continue to have the CSR committee till you exhaust that 50 lakh. If it is even used up, then in next 3 years, whatever, I think that's not applicable. You can dissolve your committee. But ideally, nobody dissolve the committee because you don't have the vision whether your company will have 50 lakh or 1 crore. So normally we have seen practically nobody dissolve the committee till they wait and the amount should be completely used. Obligation should be over and then can be dissolved. Yeah.
Gaurav, can a company secretary in practice appointed as the professional director in any company?
Oh, yes, sir. There is no restriction as such. Professional as in maybe an independent director or yes. So as a non-executive director, he can be appointed.
If it's a practicing CS and not the secretary auditor, then it can be. But
Yeah, yeah.
here in the new proposal, it says now the secretary auditor, if they are working for 3 preceding year, they are also not able to join the company as a director also. Not only just independent director, but the director. And the word used is a secretary auditor. So, or any legal consulting firm where there is more than 10% of the total turnover is coming from this company, then he is debarred from the independent directorship. That's the provision.
Yeah,
So
sir,
Okay, ma'am.
PCS
just
can be.
one point.
PCS
Yeah,
can be.
just one point. There is a provision in the, means they have given an explanation in the bill for that particular 3 years. Is that suppose if he is a partner of the firm, then he should be the person who is signing the documents or signing the reports. Then that would be considered. So suppose if there is a partnership firm with say suppose 6 partners, and one of the partners is signing the reports, which is maybe a secretarial audit report or the audit report, then in that case, the other partners, there is no restriction of 3 years. It is only the person who is signing. That explanation is provided in the bill. So obviously that we again need to recheck and revisit and study the implications on the other partners. But this provision is taken care in the bill is what I would like to just mention.
Okay. Ma'am, for you, as the MCA is moving towards AI-based checks and trails, what precautions should be taken? And will there be a greater need for caution even with reduced compliance requirement? Geeta ma'am? Gaurav,
Yeah, I think,
you
yes, sir.
can
Yes.
give.
So
Yeah.
yeah, so considering the provisions with respect to the DIN, cancellation, activation, surrender, and then having a cross reference in section 164, 167, in my view, yes, so we need to be very much be aware of the status of the DIN of the director. That is a very important point which is there. And obviously, in relation to the other filings that we do with the MCA, we should adequately take precautions about what we attach to the e-form, and that it is not a temporary attachment and you remove the attachment. And so all these things we need to take care, because we are filling up the forms and submitting it on the portal. So yes, so obviously some important precautions we need to take it.
Okay, Gaurav, my last question for you. Prima facie, this act seems to be moving towards ease of doing business. With reduced compliance requirement, how do you think this will impact professionals?
Yeah, so yes, it would definitely impact professionals in a way that what we have been rendering the services as corporate secretary services or other services, that will change. But at the same time, there are few more other opportunities and clarity which the law has provided. So the only way in which that we can provide more and better service is by providing a lot of value addition to the client that we have as a company secretary in the form of services that we render,
Sorry, I
whether
was
under the
Okay.
dropped
Companies
off.
Act or under the.
Yes, ma'am. Last question for you. Yeah. What are your views on how the NFRA will function? What will impact?
That time to see there's it's initial, but yeah, regulatory authorities are required considering the scam which are happening. I think they want to tighten the audit rules and requirement, but ICAI and ICSI, various regulatory authority, FICCI, everybody will have a representation. But there has to be some disciplinary body, and that was the purpose for having more transparency and more trust-based governance. And that's a need of an hour. I don't know how far these all powers will be exercised by NFRA. They will first start with the big companies, and the big four audit firm also consider this lot of authority requirement and penalty power. Penalties are there. How they will look at it, what kind of representation will be made. It may be introduced in a phased manner. So time will stay, but yeah, it's a good initiation from the government side. Let's see how it comes into the statute. No
Yes,
personal
yes.
use, yeah.
चलिए तो we will now conclude our question answer session and move to close up this insightful session on the corporate law amendment bill. It is my privilege to extend a warm vote of thanks to both of you. At the outset, I would like to express my sincere gratitude to our esteemed speaker Amita ma'am, Gaurav Pingle, for sharing your valuable insights and deep expertise with us today. Your deliberation have truly helped us and understand the progressive nature of the bill and its far-reaching implication. The session beautifully highlighted how this bill marks a significant shift towards transparency, accountability, and ease of doing business, while also ensuring that governance standards remain robust and effective. Your insights on key aspects such as decriminalization, the move from a control-based to a trust-based system, and the strengthening of frameworks like NFRA, NCLT were extremely enlightening. We also gained a deeper understanding of emerging areas such as digital governance, real-time compliance, hybrid meeting, and the growing importance of a strong IFSC system, ecosystem. These discussions have clearly demonstrated how the proposed reform are not only aimed at simplifying compliance, but also at enhancing credibility and investor confidence, thereby boosting foreign investment. Key takeaways from today's session in the evolving role of professional from being compliance focused to becoming strategic advisory and value creators. This shift truly reflect the changing expectation from our profession in today's dynamic environment. With this, I would also like to thank all the participants for their keen involvement and thoughtful queries, which made this session even more interactive and engaging. I once again thank you, our speakers and all the participants for making this session a great session. Great session, great success. Thank you all. Thank you. Thank you, speakers. Thank you all.
Thank you, ICSI.
Thank you.
As always, pleasure to be here. Thank you so much.
Thank you.